Swayam Prabha. Digital India. Educated India.
Welcome to all of you again in session 13 of the NPTEL online certification course. We will continue to discuss on the provisions related to license. We will also discuss that what are the provisions with regard to revocation of license, how the sale of the utility takes place after the revocation, and after that we will also discuss some of the cases we decided either by appellate tribunal or by the Supreme Court on these provisions. So, this is what we will study in this session. And now, in the last class I explained to you that there is a provision in the law which clearly says that if the licensee fails to fulfill the obligation as it is been mandated by the commission, then commission can very well intervene and revoke the license. The grounds are well laid down, which we have discussed in the last session, where it categorically says that if there is undue delay in fulfilling the mandates, if there is a breach of the conditions, and if the financial health is not very sound of the licensee, or on all these grounds the license can be revoked by the commission. But then for revoking the license, what is important to learn, what is important to understand is that there has to be an inquiry. That is what is clearly given in the section 19 subsection 1, which says that the appropriate commission shall inquire. Now, inquiry here would mean a kind of fact finding approach, that what exactly is been happening with the licensee, why licensee is not able to fulfill the conditions. So, that fact finding approach, that fact finding report would give the enough information, place the material before the commission that what shall be the course of action to be adopted. Because under this law, it is not only that revocation is the only solution, the law also suggests for suspension of the license. So, if the case warrants that it is not very grave and revocation is not the viable solution, revocation is not something which is very feasible, only sort of suspension is good enough to indicate to the licensee that okay, now you mend your ways, otherwise you will be losing the license. So, options are given under the law, but then what is important to understand for us, that there has to be an inquiry. If the appropriate commission decides on revocation without any inquiry, then it would be fatal. That is what it says. Now, when you look at the provisions of the law, it clearly says that there has to be inquiry done, grounds are laid down on which revocation is done, and then the relevant provision is given that what is the way out which is to be suggested. Now, when you look at the provisions of 19(2), which says that if public interest demands so, the appropriate commission may on the application or with the consent of licensee revoke his license as to the whole or any part of his area of distribution or transmission or trading. So, now why I am highlighting this? Because of the very reason that you would find that the scheme of the law is very composite. It is not that it has to be read in a very fragmented manner. If you read in the fragmented manner, then we will be missing the essence of the law, and that is why it has been suggested that the grounds are mentioned and then the follow up action should be taken on the basis of the ground which has been done. And further it says that the appropriate commission can very well serve a notice on the licensee, ask for a reason that why revocation cannot happen, and then the appropriate commission can very well ask the licensee that from such and such date your license will be revoked. Now, legally speaking, when you look at the language of when you look at the language of section 19 subsection 5, it is very clear that the date of serving notice and the date on which the license shall be revoked can very well be simultaneous. There is no need laid down in the law where it says that notice has to be given on one date and the revocation shall happen on another date. That is not what is the scheme of the law. It says if the situation is very bad, if it has been established that licensee has failed, because please do note this very point that the law is there to protect the interest of the consumers. So, if the licensee fails to deliver to the consumer, there is no reason that why the commission shall wait for serving the notice and give timeline for revocation. So, such kind of action on the part of the appropriate commission is very well allowed. Now, after revocation of license, it says that the appropriate commission shall invite the applications from the interested parties to buy the utility. Utility has to be sold because the licensee has failed to fulfill the conditions, licensee has failed to comply with the statutory requirements, and therefore, it is not a situation where revocation is done and that is all. After all, the commission has a responsibility to ensure, it has a duty to ensure that there should be uninterrupted supply of electricity to the consumer or uninterrupted evacuation of power from the generating unit to the transmission utility and from there to the end user. So, in order to maintain that chain, in order to give a comprehensive legal structure, section 20 says that once the license is revoked, what is to be done, that the interested parties will be asked to submit an application that whether they are interested to take up the license, whether they are interested to take up the business of the utilities, and if the appropriate commission believes that the applicant has all necessary credentials, then in such a situation appropriate commission can very well ask the licensee to sell his utility to the person to whom the appropriate commission has chosen. So, it is the appropriate commission which shall be playing the role only when revocation is done, and it is the appropriate commission which shall wait the application. Option of sale can be exercised only appropriate commission approves it. It is not something wherein there is an understanding between the revoked licensee and the intended purchaser or the proposed purchaser. Appropriate commission has to step in to look into the viability, look into the experience of the purchaser, look into that what kind of performance the purchaser has, and accordingly appropriate commission will take a call. Now, when you look at the provision, what it says is that in order to make the transaction very complete, 21 says that the rights, the obligations, the authorities, the duties, all these of the utilities, all these of the licensee will be transferred to the purchaser. because then the purchaser comes into picture. The licensee whose license has been revoked moves out, and then the purchaser steps in. So, in such a situation, section 21 says that vesting of utility is always in is always in favor of the purchaser. Now, here what is important is that vesting of utility will always be after sale. That is what it says, that once the sale is been done, then only the purchaser will have all the rights which was granted to the licensee. Now, in case no purchase has taken place, it may happen that the negotiation is still going on, there are certain technical glitches to complete the transaction, then it is for the appropriate commission to come up with the interim arrangements, to come up with the schemes that how the supply can take place. So, obviously, in such a situation it can request the government companies, it can ask the other licensees of other regions to step in and facilitate the whole process, again for a very obvious reason, that it is something where we cannot visualize, we cannot see, imagine a situation where electricity is interrupted because of this transactional issues, and that is why section 22 makes it very clear that if sale is not complete, if no purchase has been processed, or there are some issues in that giving a finality to it, then let the appropriate commission make the scheme for the same. It has to be done in the interest of consumer or the public interest. Now, you can very well understand here and take note of this very fact that right from revocation to sale and to the interim arrangement, all these are driven by the idea of public interest, and public interest here what would mean is in contradistinction with the interest of public sector utility. It is not about catering the need of public sector, it is not about catering the need of individual player, it is all about that invisible entity for whom the power sector works, for whom there is a kind of plan that there shall be quality supply of electricity, and that is what is sort of parameter to understand that in what situation the public interest criteria fulfills. Now, 23 is another important section. If you can recall, we have also discussed while discussing distribution that the appropriate government has a power to give necessary direction to the generating companies under section 11. Now, here under the provisions on licensing, you would find that section 23 is something similar to section 11. There the power is given to the appropriate government, here the power is given to the appropriate commission. So, appropriate commission can very well give power, very well give the directions to the licensees for regulating supply, distribution or consumption or use, but that when there is an issue involved of efficient supply, when there is an issue involved of securing the equitable distribution of electricity or promoting competition. Now, equitable distribution is for law student becomes a very important terminology. Why? Because in that way it somewhere brings in the idea of distributive justice, that it is not only about the one who has the ability to pay, those customers alone should be catered. Equitable, the word equitable somewhere brings in that idea that whosoever is in need, that need has to be addressed, and that is why this term to me appears to be of great significance, that how do we read equitable distribution? Does it mean that in a crisis like situation in rural areas, there has to be necessary instruction by the appropriate commission to the licensee that you ensure that there is an uninterrupted supply of electricity? Let us say for example, there is a tsunami like situation where there is a complete power cut, and then the licensee may be instructed that okay, you pull in your resources so that at the earliest things should be restored in that region. So, 23 for that matter becomes very important, and for that to me equitable distribution is a very important, is a very speaking terminology in the legal understanding. Now, when you look at the scheme, as I said, it is not only the revocation which has been suggested. The law also suggests suspension of distribution license. Now, please do take note of this fact. Here it is not talking about the transmission, it is only section 24 is talking only about the distribution. So, what is important is that there could be a possibility where the distribution licensee fails to maintain uninterrupted supply of electricity, unable to discharge the functions and duties which has been entrusted by the commission, or fail to comply with the directions which are being given by the commission, or it has violated the terms and conditions. In all these situations, distribution licensees will have to give up the license for interim period, for temporary period. Suspension is the design which has been introduced by the law, that appropriate commission can very well suspend the license. Here it is different from revocation. Here it is not about completely asking the licensee to stay away from the business. Here it is only suspension. Obviously, a timeline is to be given to the distribution licensees to make necessary corrections in the approach, to put in necessary efforts to fulfill the conditions. But if the distribution licensee fails to do so, then in such a situation it can graduate to the revocation of license, because then in such situation suspension cannot continue for infinite period, and that is why it has been said. But then it is important to understand that no suspension shall take place unless and until a reasonable opportunity is given to the distribution licensee. And the word reasonable before opportunity in law has a very defined significance. That opportunity should not be a mere formality. It should not be simply a kind of ticking the mark that okay, this criteria has been fulfilled. The opportunity should be given in such a way so that the distribution licensee presents all the necessary records before the commission, that see whatever the allegation been made, those allegations are unsubstantial, those allegations are unfounded, we have been doing as per the requirement. So, reasonable opportunity needs to be given, and while giving reasonable opportunity, it is also to be taken into mind, it is also to be taken note of that appropriate commission must not act with prejudiced mind. There should not be any malafide intention that the appropriate commission decides something beforehand and then follow the procedural requirements, then it would be fatal, and perhaps the action of the appropriate commission will certainly be declared illegal by the court, by the tribunal. Now, this is what it says. Now, suspension may lead to revocation, that is what it says, and then if it is leading to revocation, then there has to be a sale of utility to be done within 1 year of time, that is what the section 24 says. And it also suggests that in interim period administrator can be appointed to look into the utility. So, one thing is important to understand that under the law, in situation of revocation or in situation of suspension, the law suggests for the appointment of an administrator. So, administrator is to be appointed only when you have operation of utilities, and as I said, vesting of utility can always be only to the purchaser and to no one else. Utility shall be vested only in the purchaser once the purchaser is been identified by the appropriate commission. Now, these are the laws with regard to revocation, suspension, vesting of utility in purchaser, sale of the utility. Then we have in the last session also read about what are the provisions related to licensing. Now, let us look at some of the cases which have been decided by the tribunal or by the by the Supreme Court. Now, this one is 2006 Act, which relates with Western Supply Company of Odisha versus Odisha Electricity Regulatory Commission. This is a very prominent case, because more than one cases have come before the tribunal and even gone to the Supreme Court. This is a case wherein Odisha government has introduced reform and unbundled the SEBs. If you can recall, I have said this in first few classes, that Odisha state was the first state to welcome the reform and decided to unbundle electricity boards in different activities, and one such activity was privatizing the distribution utility, where Western Supply Company of Odisha, Northeastern Company of Northeastern Supply Company of Odisha, or Southern Supply Company of Odisha, all these three companies as a DISCOMs were established in furtherance of that reform. Now, what has happened is that in this case, these DISCOMs, they were allegedly not following the conditions, and because of that their license was suspended under section 24. Now, DISCOMs objected to this. DISCOM said that no procedure was followed, notice was not issued, and grounds on which the suspension was said, it was not very appropriate. The commission has not given the opportunity to the appellant to present the case. Now, looking into the facts and circumstances of the case, appellate said that when the appropriate commission has issued the notice, prior to issuance of the notice, appropriate commission had already made an adverse remark on the functioning of the appellant, and that is what the appellate tribunal said, that adverse remark somewhere reflects that the commission had made up its mind, and then after that the notice is being issued, which certainly appears to be a case of empty formality, and that is why the court said that this is something is in breach of the statutory scheme. And also it says that the grounds are clearly indicated, where let us say for example, it says that willfully not supplying the electricity, or there has uninterrupted supply of electricity, then in that situation it said that it has to be a persistent one, persistent disruption. If it is one of disruption of supply of electricity, then it should not be brought within the ambit of section 19, which talks about the grounds of revocation. So, in that regard, the court has made this, the appellate tribunal has made this observation, that the notice has to clearly spell out that what are the grounds on which the tribunal has cancelled or tribunal has decided to suspend license. Why this clarity is needed? This clarity is needed so that the licensee will bring the justification. Licensee shall submit the the averments in support of the action what it has been taking, and that is why in this case of 2006, the appellate tribunal rightly said to the Odisha Electricity Regulatory Commission that your action is not as per the law, and the liberty was given that they can very well take action afresh, and they can follow the law and then decide accordingly. Now, this 2017 again judgment of appellate tribunal is you may say follow up of 2006 judgment, because the same parties are there. What happened after 2006 judgment? The regulatory commission followed the process again and then served the notice, and on that premise it has decided that the license of the DISCOM should be revoked. So, revocation of license was decided of the appellants. As I said, there were 3 appellants, 3 DISCOMs, the Western Supply, Northeastern Supply and Southern Supply. The appellants alleged there was an allegation against there was an allegation against the DISCOMs that they have transferred the shares to RIL without the approval of the appropriate commission. Then it was suggested, it was also said that they have promised to infuse capital, but then they have not done so. They have not started the work as it was suggested. They have not maintained the obligation what is been asked for from the power grid, from the transmission utility, and from Gridco. So, these allegations were made against the appellant, and on these allegations detailed inquiry has happened. Detailed inquiry has happened in terms of a periodic review of the functioning of the DISCOMs. Now, those periodic reviews were being considered as those periodic reviews have been considered as a part of inquiry under section 19(1). Code has made this, the appellate tribunal has made this point very clear, that when you look at the look at the language of section 19(1), there is no procedure laid down to make inquiry. 19(1) does not talk about any set procedure. So, procedure has to be determined by the appropriate commission. What is needed is that it must be in conformity with the principles of natural justice. So, the tribunal said that those periodical performance review was in the form of inquiry, because during that process the appropriate commission has given opportunities to the appellants to establish that how they are fulfilling the statutory requirements, how they are fulfilling the conditions which are being given, which are being agreed upon between the parties. So, considering that fact, in 2017 the tribunal decided that the decision to revoke the license of the appellants was good in law, it was in pursuant to public interest, and then the tribunal has also said that the appointment of administrator is again as per section 21D, because the sale of utility has not taken place, and administrator can very well sell the utility as it has been provided under section 21E. So, you look at these two cases, the same party, when they have established before the tribunal that the procedural requirement of notice is not been followed, tribunal got satisfied and tribunal said yes, that is not been done, you go again for a fresh inquiry again took place, and then the finding of the inquiry was that the appellants were not committing themselves to improve the power sector in the state of Odisha, and therefore tribunal said that it was right on the part of the appropriate commission to revoke the license. Now, there is another case which is again related to revocation. What happened in this case was that this is again transmission license was given to the appellants, and then they were after getting that license they were supposed to establish the infrastructure to lay down the wires and all for evacuation of power from western region. This was a very important project, that is what even the Central Executive Authority has indicated. Now, they have delayed it, they have not started the work, and because of that there was huge loss to the generating companies. Now, in this case the appellants argued for force majeure, because no authorization was given under the Telegraph Act to take necessary permission or necessary authorization to carry on the construction work. The court said that okay, if the permission has not given under the Telegraph Act, it certainly amounts to force majeure, but then even after giving the extension of time to complete the work, the licensee has failed to prove the sincerity and integrity to finish the work, and therefore the appellate tribunal in this case has said that revocation is very well justified because of the very fact that the project is important and no further delay shall be allowed. So, you can very well find out from these judgments that how appropriate commission constantly monitors the activities of licensees, and that is being done for serving the purpose of the law. This is another judgment which is again with regard to deemed licensee, where NTPC Vidyut Vyapar Nigam Limited has come into existence as subsidiary of NTPC. It was into business of sale and purchase of electricity. The question was raised that whether this Vidyut Vyapar Nigam Limited falls under the category of deemed licensee as it has been given under 5th proviso of section 14. Now, in this case it was suggested that what falls under the exemption criteria is when the earlier licensee has been converted into a company, because the exemption has been given to continue the activities which was being carried out by state electricity boards. So, in this case the court observed that Vidyut Vyapar Nigam Limited is not incorporated under the Companies Act, and thus it is not a result of unbundling of SEBs. It is simply a company which has come, which has been which has been owned by the NTPC. And the Vidyut Vyapar Nigam Limited is not a result of unbundling. It is not that in pursuance to that reform, the board decided that let this new entity now take up the activities which was earlier with the electricity boards, said that in such situation exemption is not needed, they have to again go and apply for fresh license. This is another interesting case which again relates to license, that where it has been suggested that for rural electrification, to promote rural electrification, if area is notified, then the one who has been given the responsibility, they need not obtain the license. Now, in the Sai Electrical Power, what has happened is that government of Delhi recommended that certain areas in Delhi are not to be notified as rural areas, so that the ordinary process for granting license to be followed. Now, Sai Electrical challenged the decision before Delhi High Court, said that this is a bad decision, this is arbitrary. Now, Delhi High Court said that which area to be demarcated as rural areas is purely a policy decision, and on this kind of prescription, on this kind of stand taken by the government, the court must stay away, court must respect the decision of the government. And moreover, the court has said that the one who may get the license, the one who may be allowed to operate as a licensee in rural area, that entity does not have any vested right. It cannot say that okay, had this been notified as rural area, I would have become licensee. The court said that that kind of claim is not acceptable in the law. So, this is again another very important instance to understand that how the policy decision is being kept away from judicial scrutiny. This is one decision with regard to the understanding of section 23. That section 23, if you can recall, it says about the power of the appropriate commission to give directions. Now, question is that whether under section 23 directions can be given even to generating companies, because of the very use of the word supply. Now, supply word is used under section 2 subsection 70. Now, under section 2 subsection 70, when supply word is used, it is used in a very broad sense, which certainly involves also generating companies. But then court looked into the scheme of the law. Court says that generation is being dealt under part 3 of the act, license is being dealt under part 4 of the act, and part 4 presents a kind of complete comprehensive code for dealing with the license, and therefore, it would be wrong if we confer this authority on the appropriate commission to give the necessary direction to the generating company under section 23. Why? Because section 23 is only for licensees, and generating companies are not required to take license. So, the court in this case said, and matter has gone to the Supreme Court, a good case to read and understand on the scheme of the law, or good case to read on what is the significance of purposeful interpretation of the statutes, a purposive interpretation of the statutes, and how that purposive interpretation helps the court in arriving at the decision. In this case, the court has also highlighted the significance of marginal note, heading of sub part of the statute, that how it plays a role in clearing the ambiguity. So, in this case, the court has said that 23 relates only to the licensees. Generating companies are not required to take license, and therefore, 23 will not be applicable to give any direction to generating companies. So, a very significant judgment where the court has clarified the law, that how individual provisions are to be read in the context in which it is being designed. So, that is what the court has said. This is another important judgment, just to highlight that the railways are being given a separate status. In this case of 2012, the Supreme Court makes it very clear that as far as railway is concerned, they need not obtain the license, and they need to govern under the Railways Act of 1989, and the reason is that that is a special law, and a special law needs to prevail over general law. So, any provision related to construction of transmission line or distribution installation in railways, all these needs to be dealt under Railways Act, and there is no need to obtain any license. So, this is all for this session. Thank you very much.